Ready, start. As observed here in above, the learned arbitrator rejected claim number 4, namely, under the head construction of railway siding, the award declared by the learned arbitrator came to be confirmed by the learned commercial court Jaipur in an application under section 34 of the Arbitration and Conciliation Act. Feeling aggrieved, the respondent preferred an appeal under section 37 of the Arbitration Act before the Commercial Appellate Court Division Bench of the High Court of Rajasthan at Jaipur. By the impugned judgment and order, the High Court has allowed the said appeal and has set aside the award passed by the learned arbitrator and confirmed by the Commercial Court Jaipur. Feeling aggrieved by the impugned judgment and order passed by the division bench of the High Court, the original claimant, the appellant, has preferred the present appeal. The learned senior advocate has appeared on behalf of the appellant, and learned solicitor general of India has appeared on behalf of the respondent para. The learned senior advocate appearing on behalf of the appellant has vehemently submitted that in the facts and circumstances of the case, the High Court ought not to have interfered with the concurrent findings of the learned sole arbitrator and the learned commercial court under section 34 of the Arbitration Act by giving an alternate construction to the CMDA. It is vehemently submitted that by passing the impugned judgment and order, the High Court has exceeded in its jurisdiction in interfering with the award passed by the learned arbitrator, confirmed by the learned commercial court while exercising the powers under section 37 of the Arbitration Act. It is further submitted by the learned senior advocate appearing on behalf of the appellant that under section 37 of the Arbitration Act, the scope of judicial inquiry is narrow and does not entail giving own construction to the contract. It is submitted by disturbing the findings. The High Court has gone beyond the limited scope of inquiry planned under section 37 of the Arbitration Act. It is further submitted by the learned senior advocate appearing on behalf of the appellant that the division bench of the High Court has failed to appreciate that the interpretation made by the learned sole arbitrator on the clauses of CMDA was plausible interpretation, and therefore the same should be allowed.